Hello and welcome to the day 14th of our 100-day prelims challenge 2018. Today we are going to continue with the polity and Indian constitution, and in case you can find all these challenges on our website, and you can download the explanations also from there, the answer key and explanations. You can watch these videos on YouTube channel Prudence IAS. Today we have picked up these 10 different topics. In case if you want to revise, you can pause the video and revise these following topics. These are the right to constitutional remedies under Article 32, the provisions of preventive detention in India, borrowed features of Indian Constitution, prerogative writs, different kind of writs that we have already discussed in our previous video lecture, fundamental rights, cabinet mission plan, the token cut motion, money bill, immunities of member of parliaments, and the drafting of Indian constitution. It's a history. So the source that we have referred is the standard sources that are Lakshmikant and NCRT. So in case if you want to revise, you can pause the video and revise. So let's start today's 100-day challenges. First one is consider the following statements about Article 32. It is a basic feature of our constitution and cannot be taken away. This is correct because Supreme Court has interpreted the our right to constitutional remedies as one of the basic structures of our constitution, and it cannot be taken away even by the amendment. So otherwise, if this article is abolished, then the constitution has to be rewritten again. So, and second option is president can suspend the right to move to the court under this article during national emergency. So this right to remedy, constitutional remedy, right to move to Supreme Court for the enforcement of fundamental right can only be taken away by the procedure established in the constitution, and the constitution provides that in case of national emergency these article 32 can be suspended. So obviously second one is also correct. So the answer would be C. Let's read the explanation. Supreme Court has ruled that the article 32 is a basic feature of the constitution and cannot be abridged or taken away. So the Supreme Court has along with the secularism, sovereignty and other things also recognized the article 32 as the basic structure of our Indian constitution and cannot be taken away even by the constitutional amendment. And right to move can to the courts can be suspended while there is a national emergency. That provision is in Article 359. So you should be aware about different articles related to emergency from Article 352 to 360. We should go through them, and in case we are going to frame the question, so you will follow those things also. Now let's move on to the question number 2. Consider the following statements about preventive detention. Preventive detention provisions are mentioned in which article? Article 22 of Indian Constitution, which provides some immunities against the detention, normal detention of people as well as the preventive detention. Preventive means a person who can commit the crime in the future. So they are arrested. It is a kind of threat in case if there is a threat to national security or the stability in the society. Such arrests on the possibility of such happenings are known as preventive detention, and they are different from what the normal detention and arrest is. So this option, let's see the options. Every case of preventive detention must be authorized by law. Yes, this cannot be enforced by the executive, means government cannot just arbitrarily arrest anybody under the preventive detention, but there has to be the law on which these kind of arrests are made. So there has to be a legal explanation to why people are, someone is being arrested under the preventive detention. Second option is preventive detention cannot be extended beyond a period of 1 month. This is not 1 month but 3 months. So preventive detention, so the second option is wrong, and so the correct answer would be A, one only. Let's see the explanation. Preventive detention, every case of preventive detention must be authorized by law and not at the will of executive. So the government cannot arbitrarily arrest people. Preventive detention cannot extend beyond a period of 3 months. Every case of preventive detention must be placed before an advisory body comprised of judges of high courts or a person qualified to be the judge of high court. The case must be presented before the advisory board within 3 months. So this advisory board shall be of the judges of either high court or those people who are qualified to be the judges of high court. They will analyze the case of preventive detention, and such board has to be consulted within the 3 months of the arrest. So the key word is here in the law of preventive detention is, that is, it has to be authorized by law, and the grace period is 3 months. Up to 3 months, this detention can hold on. A continued detention after 3 months must be having a favors of the advisory board. So advisory board will decide whether this person can arrest can be extended beyond the 3 months or not. A person will be given opportunity to afford earliest opportunity to make a representation against the preventive detention. No person can be detained indefinitely. So obviously there is a provision, that is, after 3 months the advisory board will decide, and there is a provision for getting a representation against the preventive detention if a person is arrested. So this concludes the very important concept, preventive detention, which has been the provisions given in Article 22 of our Indian Constitution. Should be familiar with this. UPSC has asked this many a times. Let's move on to the question number third. Which of the following features are borrowed from US Constitution? US Constitution was one of the earliest written constitutions. USA is the first democracy, while India is the largest democratic country in the world. So we have borrowed the the parallels are like US Constitution is written constitution, Indian Constitution is also written constitution. Then fundamental rights, judicial review, and the preamble has been inspired by the Declaration of Rights of United Nations. So obviously all the three have been borrowed. Apart from the written constitution, the provision of vice president as the head of Rajya Sabha, that is upper house. So all those provisions are from USA Constitution. So option would be D. Following features were borrowed from US Constitution. They are a written constitution, executive head of state known as president, and his being the supreme commander of armed forces. This concept, that is, the president is going to be the supreme commander of the armed forces, and he or she represent the supreme commander of armed forces, that has been borrowed from America. And the written constitution, then the vice president as ex officio chairman of Rajya Sabha, fundamental rights, Supreme Court provisions of states independence of judiciary and judicial review, one of the very important concept being borrowed from America. Most of you must be knowing this. Preamble, the removal of Supreme Court and High Court judges. These all are done, have been borrowed from American Constitution. Consider following statements regarding the prerogative rates. The five type of rates which we have already, few of them have been discussed. The writ of mandamus and prohibition we have discussed in our last video lecture. So let's see the options. They are borrowed from the Constitution of USA. No, actually, these writs, as you can see from their names, habeas corpus, mandamus, prohibition, certiorari. So these are borrowed from Britain, not from America. So first option is wrong. They can only be issued by Supreme Court. No, basically these five writs, these prerogative writs can be issued either by the Supreme Court or by the High Court or by any lower court in case if the Parliament makes a law. So if there is a law made in Indian Parliament that a particular lower court can also issue the following writs, then that court is going to be authorized as the issuing authority of these writs. So the condition is like High Court, Supreme Court, or any authorized court authorized by the national law. So second option is also wrong. So the answer would be D, none of the above. There are five major types of writs. These are the habeas corpus, to have a body, mandamus. We have already discussed the mandamus, the provision of mandamus in which there was the public officer is required to why they are not doing a particular duty. Then there is a prohibition in which the higher courts can restrict the lower courts about any judicial proceeding, quo warranto and certiorari. That is, we are going to discuss them in the coming MCQs. These are borrowed from England English law. In India, both Supreme Court and High Court, as we have discussed, the High Court, Supreme Courts, or further up any lower court which has been authorized by the law of Parliament, they can issue these following five writs for the local limits of jurisdiction of such courts. So this is one of the important questions regarding the writs and who can issue the writs and from where we have borrowed. We have borrowed the writs from Britain. Let's move on to the question number 5. Consider the following statements about cabinet mission plan. So this is cabinet mission plan again. This was being discussed in our history MCQs as well. So you should be thorough with the cabinet mission plan, Cripps mission, then communal award, and those major instances of Indian constitutional development. First option is it recommended a separate state of Pakistan. No, it recommended the United State of India. So there was the provision of the demands of Muslim League were not fulfilled by this cabinet mission. They were not taken care by this mission. So Muslim League again was angry with this the proposal, and they obviously rejected the cabinet mission plan. It abolished the communal electorates. So yes, there was the abolition of communal electorates based on the uh, communal lines by this cabinet mission. So option would be B only. The cabinet mission recommended an undivided India and turned down the Muslim League's demand for separate Pakistan. The cabinet mission restricted the communal representation. It provided that all the members of interim cabinet would be Indians. There would be a minimum interference of viceroy, and it also provided for the formation of constituent assemblies on democratic principles of population. It recognized Indian right to cede from the Commonwealth. So it had all the provisions of a united India. Cabinet mission, it rejected the demands of Muslim League and it proposed a united India in which all the members would be the interim cabinet members would be Indians. So this is a concept related to the evolution of our constitution, the historical underpinnings of our constitution. You can also read this in Lakshmi Khan, so and so page. And let's see the question number 6. Right to property was a fundamental right until uh, the article 42nd that came in 1978 is also known as mini constitution because it had all the major provisions of amending the preamble, then shifting this right to property from the fundamental right to a legal right from article 31 to article 300A. So this 42nd amendment, you should be aware about what following changes occurred after this amendment, and this was being brought in 1978. So the answer would be C. Let's read the explanation. Right to property was a fundamental right before 1978. The Constitution 42nd Amendment taken away the right to property. So they shifted from Article 31 as the fundamental right and was made a legal right under the Article 300A. So there was a reduction in the fundamental rights, and the right to property was made a legal right under Article 300A. So this was it. And the token cut motion. Cut motions are basically aimed at humiliating the government and reducing the amount of any particular bill or budget. So the token cut motion aims that the amount of demand be reduced by the 1 rupee, 10 rupee, 100 rupee, or none of the above. So answer is to reduce it by 100 rupees. So this is basically symbolic, and this is against, this shows the disagreement of the parliament from the government's uh, allocation policies, the allocation of finances to particular planning. So in case this motion is passed, it shows that government's spending are not proper, and this token cut motion of 100 rupees is a symbolic and humiliating on the government. So let's read the explanation. A token cut motion aims at the amount of demand being reduced by 100 rupees in order to ventilate a specific grievance which is within the sphere of responsibility of government of India. Actually, the token cut is symbolic. So this is symbolic act that the parliament does not agree with the government's policies, and it is humiliating for the government. To be precise, all cut motions are humiliating for the ruling party or the coalition. The cut motions provide the members maximum opportunity to examine each and every part of the budget and criticize the government policies. So in case if the cut motion is passed, that indicates that government is not properly allocating the funds to the particular section of the budget. So this is related to the cut motion. You should be aware about this factual knowledge that 100 rupees cut motion has the amount of reduction of rupees 100 is kind of factual question. Also has the concept behind this to humiliate the government, and it is symbolic. So let's move on to question number 8. Consider the following statements about money bill. It can only be introduced in Lok Sabha. This is correct. It is only introduced in Lok Sabha, and that too on the prior recommendation of president. So only president, those the money bill is the bill that is mandatorily being recommended by the president. So mostly the government bill, the money bill is, that means that the executive, it is being approved, authorized by the executive as such. So these are the checks and balances for just not any arbitrary bill can be a money bill. That bill has to be special, that bill has to be recommended by the president, and it can only be introduced in Lok Sabha. This is the matter of finances. So the option is obviously first one is correct while second one is wrong. Only those financial bills which contain provisions exclusively on the matter listed in the Article 110 of the Constitution are called money bills. So there is a provision that not all the financial bills are money bill, but those which have the provisions exclusively of the money related to Article 110. They have certain matters which are being listed in Article 110. If that bill contains those matters, then only it is called the money bill. There was a controversy because the present government introduced the Aadhaar UIDAI bill as a money bill, and it did not contain the significant portions of what is being mentioned in Article 110. So there was a controversy. In case if you want, you can just read about that controversy of UIDAI bill, which the present government introduced as a money bill. A money bill can be introduced originated only in Lok Sabha, that is Legislative Assembly in case of bicameral legislature or in the states. A money bill can be introduced only on the prior recommendation of President or the Governor in the case of states. So the states follow the similar guidelines in case of money bills in their respective states. Consider the following statements regarding the immunity of members of parliament. They cannot be arrested for the they cannot be arrested for the cases, civil cases, when parliament is in motion. This is obviously true. Under the Article 105 there are certain immunities discussed about the members of parliament, so you should be aware about that. They cannot be arrested in cases of civil cases when the parliament is in motion. That is, these safeguards are for not hampering the process of legislation which is of national importance. So civil cases you cannot arrest a member of parliament if the parliament is in session. They do not have the any immunity against the preventive detention during this period. Obviously preventive detention is somewhat stringent, and it requires that it is in the extreme cases that preventive detention is being applied. So this is this option holds. They do not have, this is also true, that they do not have any immunity against the preventive detention, but only the civil arrest cases. So both the options are correct. Let's read the explanation. Individual privileges of members of parliament under the Article 105 include that they cannot be arrested 40 days prior during the session and 40 days after the end of session. So the grace period is 40 days, and we have already discussed that this preventive detention in which a person can be held maximum of 3 months on the grounds of preventive detention, and then the advisory body comprising of judges of high court or similar qualification judges, it will decide whether the person has to be, the preventive detention of the person has to be further extended or it has to be revoked. So these are all the relevant information. These MCQs are very important from the point of view of prelims. UPSC can always frame the complex questions from these concepts, so you should be aware of this. And individuals, and this is the grace period is 40 days prior and 40 days after the end of the session in the civil cases. However, such immunity is not in the criminal cases or preventive detention. So if case a member of parliament is being found guilty in any criminal case or preventive detention, they can be arrested even if the parliament is in session. Now the last question, consider the following statements about the drafting of our constitution. The idea of constituent assembly was originally put forward by the Congress. This option is incorrect because it was the socialist leader M.N. Roy who proposed the uh, idea of having a constituent assembly in as early as 1934, and it took more than 3 years to draft our constitution. No, it took around 2 years and few months. So this second option is obviously also not correct. So the answer would be D. Let's read the explanation behind. Our constitution is unique. It is unique in many ways. We know that our constitution was framed by the Constituent Assembly, and as long as 2 years, 11 months, and 18 days. So it's almost 3 years, but not 3 years. 2 years, 11 months, and 18 days. It must be noted that the idea of Constituent Assembly was not of the Congress. The idea was put forward by M.N. Roy in 1934. So you should be aware about the history of drafting of constitution. We have already discussed one MCQ in our previous lecture regarding the drafting of evolution of this constitution and constituent assembly. So stay tuned for more such MCQs on our channel, and we hope to continue this polity series in the upcoming days. Have a good day.